Good morning. Are you Isaac Darby? And Mr. Darby was previously in court, entered a plea of guilty to the second-degree felony offense of assault on a peace officer. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Hold on. Are there any additions or corrections?
Not from the defense, Your Honor.
Nothing from the state judge.
And so, Mr. Darby, when someone's sentenced, I also get jail incident reports. And you've got several, and several of them include fighting. And so if I follow this agreement this morning, I want you to understand something, because part of your agreement is that you go to ISF. That's a 90-day program to help you make better decisions, which obviously you haven't figured out yet. If you get in trouble when you're in ISF, then your probation can be revoked before you ever hit the streets again. Do you understand? So whatever's going on with the fighting and acting the way you're acting, talking the way you're talking to the correctional officers, has to stop immediately. If I get an incident report from our jail before you go to ISF, you may not even make it to ISF. So it's going to be up to you if you really want to take advantage of this opportunity and be able to get out, serve your probation, and have a normal life like the rest of us. Do you understand? So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. Thank you. Find sufficient evidence to find you guilty, and at this time find you guilty of the second-degree felony offense of assault on a peace officer. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to follow the agreement and probate that. You'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which include entering and successfully completing the cognitive track of the ISF program. If you do all of that, this is a great opportunity, because it means for all practical purposes your case here in court is over, and you'll serve that time while you're out on probation. You can be brought back into court, and you can be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. And I will sign a dismissal as part of this agreement in clause number 24, DCCR 0697, as soon as that comes through. Good luck to you, sir. Take advantage of this opportunity.
Thank you, Your Honor.
Good morning, sir. Eugenia Pew. Yes, ma'am. And will your client waive the formal reading of the motion?
He will, Your Honor.
To probation. And will he waive the formal reading of that motion?
He will, Your Honor.
It shows that you were placed on probation June 22nd of 2015 for the offense of retaliation, and that was a 5-year deferred probation that's been extended. Is that correct? Yes, ma'am. It alleges in count 1 that you committed the new offense of robbery, threats, November 27th of 2020 in Harris County, Texas, and is that true or not true? Count 2 alleges that you committed the offense of assault family violence on November 27th of 2020 in Harris County, Texas, and is that true or not true? And then finally, count 3 alleges that you committed the offense of robbery December 5th of 2020 in Harris County, Texas, and is that true or not true? Did you enter, and the state abandons 4, 5, and 6, correct?
That's correct.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because you actually did what they say? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Pugh's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence at this time to find you guilty and find you guilty of the third-degree felony offense of retaliation, sentence you in accordance with your agreement for a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff. Good morning, sir. You're Adrien Cabalero?
Yes.
And Mr. Caballero was previously in court, entered a plea of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor.
None from the state judge.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find that sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, and in cause number 24 DCCR 2201, defer all proceedings and place you on probation for a period of 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed and you'll never have the felony conviction. The other side to that is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could be sent to prison for anywhere in the punishment range, which is up to 10 years in prison. Do you understand? And I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir. Good morning, you're Londi Vick. And Ms. Vick is charged with failure to comply with sex offender registration requirements and was found not competent to stand trial, sent to, and this is a state jail felony, and was sent to the appropriate facility for competency restoration and has been either in custody and or at that facility for quite some time. The offense date is January 30th of 2023. So at this point, she has not regained competency, and we are past the time frame on a state jail felony where we could continue to hold Ms. Vick.
Correct, Judge, and if I may, just for the court's knowledge and to document the record, she was found incompetent by this court and sentenced to the Big Spring State Hospital in July of 23 and again in February of 24. And so, yes, she has expired the length of time we could have incarcerated her in the state jail, yet she has failed to regain competency. Deputy Berry has worked diligently the last several weeks trying to find a place for her, and I just wanted to document for the record based on the nature of the offense and the fact that the state is in a position to now have to dismiss the case, the efforts that Deputy Berry has made to try to secure her some kind of location to help her and maybe step forward from there. So if she may, Judge.
Sure,
let
yes,
you know
ma'am.
what she's done as an officer of the court.
Thank you, Ron. We have tried several different locations, however, due to the nature of the registration, we are unable to locate proper placement at this time. Also because lack of income is going to be an issue as well. We do have plans to do reassessment today, evaluation to see if she would need immediate stabilization for inpatient upon release.
Okay.
At this point, and then we can work from there to try to get her established.
Okay.
We also do have our mental health professional with Spinal Top looking into possible another state hospital placement.
Okay.
And Judge, obviously, I don't know if she will be able to comprehend this, but she would be required upon her release regardless of where she goes, if they find a placement or not, to register.
Right.
And we will try to closely monitor that and advise the appropriate agencies that she needs to register, that she has been released due to these circumstances, so that at least the community can get advice if necessary.
Okay, I appreciate everything both of you have done to try to get something figured out. Obviously, Miss Vic, if you don't register like you're supposed to when you're released, you're going to be right back in custody.
Yes, ma'am.
Do you understand that you're supposed to register as a sex offender?
Yes, ma'am.
And so when you're released from jail, you have to go to the police department and do that. If you don't, another case is going to be filed and you're going to be right back in here and we can go through this whole process for the next 2 years. Do you understand?
Yes, ma'am.
Okay. All right. Thank y'all. Appreciate everything you're trying to do still. And I'll sign that when it comes through. Good morning. Are you Nakia Latrell Jackson?
Yes, ma'am.
And Ms. Jackson, in cause number 19-32344, you were here before. You're on a 10-year deferred probation for burglary of a habitation. And I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, yeah.
Yes, Your Honor, we have.
Are there any additions or corrections to the report?
Not from the defense.
No, Your Honor.
All right, Mr. Rojas, and there was no agreement, correct?
That is correct. Yes.
All right.
Right.
Okay.
Yeah, Judge, we went over the PSI at the jail, and I discussed her the possibility with Ms. Jackson about the possibility that the previous recommendation had she would have been, at one point, would have been safe P. She tells me that she doesn't feel that she needs safe P. She thinks that all the tools she needs, she got from ISF when she was at ISF. Her problem, she thinks, is that when she was released from ISF, she just was homeless, didn't have any place to go. And that one thing led to another. She didn't have a home, didn't have a phone, didn't have transportation. And that's one of the reasons, that she couldn't get into the drop program, which led one of the reasons we're here today. If you read her comments in the PSI, she's asking for another chance, and she truly wants another chance. She tells me that if she's given another chance, she does have a job for her on the outside. She's waiting. She has a job waiting for her at Waffle House. She has two possibilities of where she could be living. She could either go with her aunt who lives in Orange, I believe, who's a school teacher in Orange, or the manager, her manager at Waffle House would let her live with them in Port Arthur. And that's what she's asking me to do, Judge. I know that it's hard because of the comments on the PSI where she didn't report, didn't go to the drop program, just kind of disappeared for a while. But she's asking me for another chance, and I think she has some comments to make whenever the court feels it's appropriate.
What's the status of the theft case and the failure to ID?
Those are pending misdemeanors, Your Honor.
Okay.
I'll probably dismiss them, but then I'll.
Okay. Mr. Nichols?
Judge, I want to make the court aware of the full history on this case. Ms. Jackson was originally on probation before this court on a 2012 burglary. She then committed this offense, and we had a hearing. I think it was a 7-year cap originally, and she was continued on probation. Since that time, she's been ordered to and successfully completed ISF, but then continued to violate probation and was ordered. Would have been sent to safety last year, but then she absconded and stopped reporting. Along with that, I don't think she's done anything really since September of 24, and that's all the violations that are alleged for this motion. So she has been given every opportunity, every service that we offer to try to help her, and she keeps coming back to using and not participating in probation. So I think revocation is an order, Judge.
Thank you, Mr. Nichols. All right. Ms. Jackson, do you want to say something?
Yes, ma'am. Thank you for letting me appear and be able to speak on my own behalf today. Judge, whenever I did appear before you last time, I was on 2 10-year probations. I did complete one of them. And since then, I have been to ISF. I learned a lot from ISF. When I was released from ISF, I didn't have a stable place to live. I didn't have anything. And like he did say, I was off my meds. I wasn't in any kind of predicament to take care of myself. since then, God has blessed me to be reconnected back with my family. I have a stable family support group now, and I can stay back on my meds. If you would give me another chance, I even said I tried the JCDI program or something, maybe out to become a productive member of society. If you allow me to just try, maybe I'll double my fees on probation, do all my classes, try to get off early. I would like to try to get off early, go back to school, be a productive role model for my grandbabies. I learned so much in ISF. I didn't get a chance to fully get, if you just give me a chance to prove it to you.
I feel like I've heard that before.
I never took ISF.
Hang on.
I'm sorry.
You've been on probation since 2012.
Yes, ma'am.
You didn't successfully complete a probation. We just let you get off of that one because you got on another one. Because while you were on a probation for a burglary of a habitation, you got another burglary of a habitation. And you were lucky at that point because you got another chance. And so here's the thing. You say you've learned from ISF.
I really did.
And maybe you did. But if you're going to stay on, the fact that I'm even considering this, so you don't think you need to go to safety?
No, ma'am, if you just please, I have a job.
You're not getting out today. You're going to prison or you're going to safety. It's that simple. You're not going to keep doing things that you're not, hang on.
Okay, yes.
You're
ma'am.
not going to keep messing up and then get rewarded for that bad behavior. Does that make sense?
Yes, ma'am.
So you've been given opportunities, both tracks of ISF. You were placed on a special caseload to help you with any issues you were having, and you didn't do what they were asking you to do. So it's either special needs safety. Special needs safety is gonna take care of, hopefully, some of the mental health issues as well, correct, ma'am?
I don't know about safety.
Well, so there's a SafeP program. There's two different ones. There's your regular SafeP that's primarily just obviously drug treatment. Then there's a special needs SafeP that also takes into consideration any mental health issues and help for somebody who might need some help with regard to that, which is clearly, it looks like what you would qualify for because you have refused to go get any of the mental health treatment that has been offered and handed to you while you're on probation. So what I'm going to do today, Ms. Jackson, and I'm probably going to look, hopefully I won't, but if I look back on this again, I'm telling you now, if you're back in here, I'm going to wonder why I did what I did today. And if I have to wonder why I did something, it's usually not good. You could go to prison today for up to 20 years. Up to 20 years today, I could send you to prison. And if you're back in here and you don't take advantage of what you're given today, then you're going to be looking at that entire range of punishment, and it's probably not going to be on the low end. Do you understand? I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty. However, I'm going to continue you on probation. I'm going to order that you enter and successfully complete the special needs SafeP track. You'll get hopefully more tools and all the tools that you need to get out and complete this probation. You will be on 0 tolerance. That means you cannot miss one appointment. When you get out of SafeP, then if the probation department thinks that JCDI is appropriate for aftercare or the drop program, you miss one appointment, you miss one testing, then you're going to be right back in here with a motion to revoke. This is it. No mess ups, not even a single one. Do you understand? That's what 0 tolerance means. All right, I'm going to hand you the trial court certification. This was not an agreement. There's previously in court entered a plea of guilty to the 3rd-degree felony offense of unlawful possession of a firearm by a felon. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Judge, I know the court probably has some concern with his version of the offense as well as the criminal history. The offer was extended based on the age of that criminal history, but we would defer to what you think is appropriate.
No, I don't disagree with the age, and I think that there's obviously some other issues that we're going to address that probably can explain some of that as well. So, Mr. Thomas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 10 years in prison, but I'm going to probate that, and you'll be on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include having an assessment and following through with any mental health treatment that is recommended. Do you understand? If you do everything that you're supposed to while you're on this probation, then that means for all practical purposes, your case here in court is over, and you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you don't go to appointments, you don't follow up with everything, go where you're supposed to, if you violate the law, then you're going to be right back in here, and you will be facing the 10-year sentence that you've agreed to. Do you understand?
Yes.
I am handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this because of the case against you, but I'm required to read this. Because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. Good morning, sir. You're Michael Davis, and this is cause number 19-32496. Mr. Davis was in court previously, entered a plea of guilty to driving while intoxicated with a child under 15 years old. There was a punishment, it was sentenced, and it has been less than 30 days since then, and I've received a motion for new trial that has been filed by Mr. Parker that states that Ms. Malfino, you're in agreement with this motion because there was a mistake in y'all's calculation of time credit. Is that correct?
Correct. The purpose of this, judge, is we're trying to get him out of here because he pled out on his case, the underlying case that caused the motion in Harris County, and was sentenced to probation over there. And one of the conditions of probation, it's not safety, but it's an in-house treatment facility over there. And so we thought he had more credit because he had been arrested in October, but apparently the motion wasn't filed. And it wasn't filed till like January, so he didn't have credit for that time that he was actually in custody.
He may lose that bed over there based on that
Okay.
probation.
Um,
So ours was a state jail felony, which you allowed us to offer a 1244 on. He just didn't have as much credit as it appeared he did based on the offense date. There was not an appropriate
Right.
rule or something.
And we've got an agreement, if the court allows this, we got an agreement for a little less time, basically.
I'm fine with that. I guess I'm wondering,
And I just kind of did that off the top of my head, a motion for new trial with the nunk of the judgment and then resentencing, if that would work.
well, we would have to do the whole, if the motion, which is fine, we'll just have to go through the motion to revoke again.
Right,
Get pleas on that.
that's fine.
Is there, what about just a motion to reconsider, can we just change?
I
think
can
I
do a
need to-
motion, an oral motion to reconsider sentencing.
I don't want anything orally done
Okay.
because it won't make sense in the file that I just changed it.
Yeah.
Let's just do it this way. I'll grant it, the motion for new trial, and then you guys can get the paperwork done and we'll take that plea up in just a few minutes.
It would be okay with the court for us to just proceed on count one, which was that new offense in
Sure,
Harris County.
I'm fine with that. We don't need to, the less we have to go through and read, the better.
We got it done, she's got it.
Okay, back on the record in cause number 19-32496. And sir, again, you're Michael Davis. And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
And it's my understanding we're going to go on count one only, correct?
Yes, Judge.
Mr. Davis, I have a motion to revoke your community supervision. Shows that you were placed on probation March 3rd of 2021 for the offense of driving while intoxicated with a child under 15. And that was a 2-year term in the state jail that was probated for 4 years. Is that correct?
Yes, sir.
It alleges in count 1 that you committed the offense of driving while intoxicated third or more February 5th of 2025 in Harris County, Texas. And is that true or not true?
True.
Did you enter your plea of true to count 1 freely and voluntarily?
Yes, sir.
And because you actually did what it says you did? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, sir.
Do you fully understand them?
I think so, yes, sir.
And, well, do you understand that if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Davis is not competent?
No, Your Honor.
And so, Mr. Davis, I just want to make sure that you understand that if I follow the agreement, it's for a 120-day term in the county jail under Section 1244 of the Penal Code, which means you have the state jail felony conviction, but you will be able to serve any time in the county jail. You will be given credit on that for any time that either we had a hold on you or you were in our county jail. Is that your understanding?
Yes, sir.
All right, then I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true, find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 120 days in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you that written admonishment regarding your ineligibility to possess a firearm or ammunition. We went over that a few weeks ago. I'm not going to read it again. You understand that you are not eligible to possess a firearm in Texas. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
All right, you're Calvin Randall. And so Mr. Randall has 3 new cases. Cause number 24 DCCR 1278, charged with aggravated assault with a deadly weapon. Cause number 24 DCCR 1529, charged with unlawful carrying a weapon on alcohol premises. And cause number 24 DCCR 1530, charged with evading arrest or detention with the use of a vehicle. Then we have cause number 2136882. Mr. Randall is on probation currently for aggravated assault causing serious bodily injury. There is a motion to revoke probation in that case. There was a request previously for me to set a bond, which I did back in June of 2024. There was a bond set in that motion to revoke case, it looks like. That obviously hasn't been made. There are bonds in all of the others, a $15,000 bond, a $100,000 bond, and a $200,000 bond. And we have gone through, if I'm correct now, what y'all are saying, there were pleas on the motion to revoke, and that is set for a hearing July 2nd.
Yeah, he pled true to some of the administrative counts.
But we're set for an actual hearing with regard
Prove up the
to,
new offenses, Judge.
okay. And you're asking me to reduce the bond on those cases?
Yeah, he's got a total of like $325,000 worth of bonds on, the biggest bond is the motion to revoke bond, which is a $200,000 bond. He's requesting that, I mean, he lives here locally, he's willing to wear any kind of GPS device, whatever, his main motivation is that he would like to spend some time with his family prior to coming back to court on July the 2nd, in the event the court does revoke his probation.
Mr. Phillips Smith?
State's obviously opposed, Judge. There are some jail incident reports from May 5th. There are also others that go back to February, and then some from June of last year as well.
Well, the incidents on May the 5th is deal with, they requested that his blood sugar was above 300, and they requested that he do incident, and he says, no, I'd like to try to get it down myself. Well, they made that to be an incident.
I'm not worried
Well,
about
it was
that.
also disrespectful and encouraging other inmates to be disrespectful to ones that jail.
Yeah, there's another incident from that same
Two
day.
from that same day.
Hold on just a second. I'm taking judicial notice of the court's file in each of the cases, just to get myself kind of caught up to speed again, reviewing the probable cause affidavit that has to do with those new cases. Okay,
Two of the cases, the misdemeanors were refused by I believe, unless I'm misspeaking.
I don't know what misdemeanors you're talking about. I mean, we've got an evading arrest with a vehicle, we've got unlawful carrying alcohol, a weapon on alcohol premises, and a new aggravated assault with a deadly weapon, all new cases that have been indicted.
Yeah,
It looks like there was probably, based on the probable cause, I'm guessing there was an evading on foot, potentially, just a regular evading, because that's what one of the allegations.
For example, the weapon on the alcohol is not going to be, as a matter of law, it's not going to be viable because the premises that he was alleged to have been on does not serve alcohol. And the statute's been amended that for him to be guilty of that offense, it has to be a premise in which they serve alcohol and those premises do not. And,
The S&S grocery doesn't sell alcohol?
huh?
The S&S grocery on Concord doesn't sell
It
alcohol?
sells alcohol, it does not, you cannot consume alcohol. And the statute's been amended to say you have to, it has to be a premise where they consume alcohol.
Okay, I haven't read that, but that's fine. We still have the aggravated assault with a deadly weapon and the evading arrest with a
That's correct.
vehicle,
That is
regardless. Okay, and we're set July 2nd.
correct. That is correct.
No, your motion's denied in all of the cases, I think, based on the nature of the underlying offense that Mr. Randall is on probation for, and the fact that the allegation is a similar allegation, another aggravated assault with a deadly weapon, the evading, all of those underlying facts. I'm going to deny the motion to reduce bond in all of those cases. And we'll see y'all back on July 2nd for that hearing.
Yes, sir.
As the gavel falls and today's courtroom session comes to a close, we're left with stories that prove justice is never simple. What started as routine hearings quickly revealed how one decision can change a life forever. We saw defendants standing before the judge, some asking for a second chance, others facing the full weight of their past. Probation, ISF programs, drug tests, and strict conditions, all designed to test not just compliance, but character. Because in court, freedom is never free. It comes with rules, discipline, and responsibility. Then came the moment that shook the room, the habitual offender ruling. For one defendant, it meant the difference between a manageable sentence and decades behind bars. A harsh reminder that choices from years ago can resurface in the most devastating way. But beyond the drama, today highlighted something bigger: the delicate balance between mercy and accountability. Judges don't just enforce the law, they weigh futures, families, and second chances. Some defendants walked out with hope, others with heavy burdens, and all of them left knowing the courtroom's decisions will echo for years to come.